Hello, ladies and gentlemen. The topic I'd like to discuss with you today is some differences between the Thai legal system and the Western common law legal system in regards to criminal law and criminal procedure. The three main differences are the absence of a right to a jury trial in the Thai legal system. Secondly, the inability to plea bargain under the Thai legal system. And thirdly, the additional right under the Thai legal system of private criminal prosecutions. Starting with the first, the right to a jury trial is a fundamental feature of the Western common law tradition. It allows the factual determinations in a criminal trial to be made by a jury of common citizens. Without this right to a jury trial, the decisions in regard to facts as well as to the law would be made by a judge. And that's how the system works in Thailand. What the jury system does effectively in the Western common law system is it expands the right of the attorney, both the criminal defense attorney and the prosecutor, to argue their case to the jury as well as to the judge. This increases the rights, the abilities of the attorneys to influence the court and the jury, whereas when there's only a judge presiding over a hearing, all the determinations, both of fact and law, are made by the judge. And that's how the system works in Thailand. The second major difference is the inability to plea bargain, as we know it under the Western system, under the Thai system. In other words, criminal defendants, their attorneys, and prosecutors in the Western system often plea bargain. The prosecutor will reduce charges or select certain charges in exchange for the defendant pleading guilty. This right does not exist in the Thailand criminal justice system. The only two parties that can reduce charges against a criminal defendant are first the police. During the initial intake and investigation process, the police can effectively choose certain charges that they will send to the prosecutor's office. Secondly, the court itself. The judges, after hearing the evidence in a criminal trial, can decide which charges the criminal defendant is guilty of, not guilty of, or innocent of. What this means, in effect, is that a central role of the criminal defense attorney under the common law Western system does not exist in the Thai system. As a counterbalance to this, the increased role of the police in the Thai system in terms of intake, investigation, and controlling the way charges are presented to the Attorney General presents a fundamentally different aspect to the attorney's job than exists in the Western common law system. In other words, the job of the criminal defense attorney in Thailand will often involve a great deal of time at the police station dealing with the individual investigator and witnesses prior to the charges being officially filed by the Attorney General. The third primary difference in the Thai legal system is the right of individual citizens to file private criminal cases. In the Western common law system, the way a criminal procedure usually takes place is a victim makes a police report, the police performs an investigation and sends the investigation to the Attorney General, the prosecutor, or the district attorney, and then the prosecutor controls the case and the state is effectively the plaintiff. In other words, the victim no longer controls the case. He's a witness in the case. The prosecutor and the state government are the plaintiff and they control the decision-making process. The Thailand system is similar. However, there's a huge exception. And that exception is that it is possible for victims of crime to independently hire attorneys and to file private criminal prosecutions. They can also alternatively go through the regular system of filing a police complaint and hopefully have it go through the normal process to the prosecutor's office and have the prosecutor then prosecute. Once a prosecutor has begun the prosecution of a criminal case, it's also possible for a criminal victim to join the case. Now, this is good in terms of a victim's rights because he has more flexibility in how to proceed with his case. However, if you're a criminal defendant, this is quite bad. The reason for this is you're no longer facing just one plaintiff. You are potentially facing two plaintiffs, both the prosecutor and also the individual criminal victim. You also have potentially two adversaries instead of one. You have the attorneys for the prosecutor and also the attorneys that the individual citizen victim has hired privately. That's all we have for you today. Thank you for watching. We look forward to the next time.